This Iowa District Court is now in session. The Honorable Judge Kevin McKeever presiding.
Good afternoon. Please be seated, everyone. All right, this is FECR 133583, State of Iowa versus Mr. Younes, who is here with counsel, Mr. Powell, and then we have Ms. Zimmerman and Ms. Huddleston here on behalf of the state. The purpose of today's hearing is for me to read a verdict into the record pursuant to a trial of this matter which was held earlier this year. In making my findings, I considered all of the exhibits that were presented. I considered the briefs that were filed by counsel, and I considered the testimony of the witnesses as well. I have distilled all of that information down to specific findings of fact, which I will not go through in detail at this point. I also have enumerated in my written order principles of law, which include, among other things, all of the elements of each and every offense. Regarding count one, I will say that count one is robbery in the first degree. I did find the defendant guilty as charged to count one. Regarding count two was theft in the first degree. I found the defendant guilty under count two. And regarding count three, I do want to specifically discuss for the record that I did not think that the statement by Mr. Altador should be considered. This was a matter that I left open. Both sides argued it. I did not think it was helpful for the analysis, but nevertheless, I did think that given all of the facts and circumstances, count three was the hardest count to decide, but I did think that the defendant was guilty under count three as well as charged. And so I found the defendant guilty on counts 1, 2, and 3 as charged. All of my findings in detail or in writing will be filed immediately following this hearing. And at this time, does the state wish to have any additional record made?
No, Your Honor.
Does the defense wish to have any additional record made?
No, with regard to this case number, Your Honor, I understand that there's a sentencing date that's already been selected, and we are okay with that.
All right. Yes, Mr. Powell is correct. I have selected February 27th at 2 p.m. for the sentencing date. Is the state also okay with the sentencing date?
Yes, Your Honor.
All right. I am going to order a pre-sentence investigation. I understand that there has been a written plea of guilty filed under a different case number. I will set that case number for the same sentencing date unless one of the parties objects. Does the defense object to that?
No, Your Honor, that's what I would ask you to do. So.
All right. And the state?
No, Your Honor.
Okay. All right. So as I mentioned, I have made some detailed findings of fact and conclusions of law, which I will file immediately following this hearing. And with that,
because there are forcible felonies involved, and assume the bond conditions will be changed.
and as part of the written ruling, I have amended the bond conditions to reflect the fact that there will be no bond pending sentencing. Anything else?
No, Your Honor.
Okay. So other than reviewing your client's rights, Mr. Powell, to the various motions that might be filed post-trial, we are adjourned. Okay? Or unless, do you want to make any further record of that at this time?
No, do you wish to inform my client of his rights, or is it...
I guess for the record, you do have a right to file a motion to arrest of judgment and a motion for new trial pursuant to the rules. If you do need help filing those motions, your attorney can help you with those motions. Anything else in that regard, Mr. Powell?
No, Your Honor, thanks.
Okay, then we are adjourned. Thank you.